This class is Reasonable Accommodations Rights, Notice for Tenants. What an exciting course to be taking with the changing laws throughout the United States, and particularly in New York when it comes to disability and handicap discrimination. You often think about disability and handicap discrimination in employment law. That's where it's really, really big. But did you know that the Fair Housing Act, the Federal Fair Housing Act, makes handicap a protected class? When it comes to disability and handicap, they're interchangeable terms. State laws usually use the word disability, like the New York State Human Rights Law. It is the most interesting part of all discrimination law. And this course is going to show you that in the state of New York, in housing, tenants are now going to be getting a notice from their broker, from the property manager, in their lease to tell them not only what their rights are, yes, for getting a change to the practices, policies, procedures, to get a modification of the structure, not only their rights to these things, but also how to bring a complaint with the State Division of Human Rights, which takes the place of HUD on the state level, and how to bring this complaint when they don't get their rights in a failure to accommodate claim. My name is Andrew Lieb. I'm the managing attorney of a law firm located in the New York metro area called Lieb at Law PC. Lieb at Law has been working in discrimination law for years and years and years. We work in New York, New Jersey, Connecticut, and during snowboard season, Colorado. But I'm sure you know that federally, you can waive in to all different federal courts and we can help you anywhere. Nebraska, we're even willing to go to. Iowa, California, Texas. These laws are usually federal claims we see. And so when it comes to discrimination, I've done a lot of it. You could look me up. I've been on a lot of TV channels. ABC, Fox, Pix, Newsy, News Nation, Newsmax, I don't know, a lot. I'm in a lot of publications, whether it's the New York Times, Newsweek, local ones like, I don't know, the New York Sun, Newsday. I've been in Bloomberg. Check me out. Anyway, I'm going to be your instructor for today, and I want to share with you two main points from today's, what's our goals? Number one, if you're a transactional attorney, you're representing landlords, property managers, real estate brokers, how do you make sure that they do compliance? How do you know what the rules are? What are the rules with these regulations and statutes in the state of New York? And by the way, when the Empire State Excelsior does something, you find that other states follow suit in near term. It's one of the leaders. If you remember back at law school, you would learn California and New York. New York, when they do something, a lot of states follow. So if you're not in one of these states, maybe you want to learn of what's coming down the forefront. So one way is to do compliance. That's one of the things I want you to learn. But the second and more important thing I want you to learn is how this is going to affect discrimination cases moving forward. It's unknown, but I have a crystal ball, and I'm going to share with you what I'm saying. Anyway, today's focus is on reasonable modifications and accommodations. If you're a New York City practitioner, you'll know that under the New York City Human Rights Law, they combine those terms and just use the word accommodation as an umbrella term for both. I hope you realized already that there's a multitude of laws when it comes to disability discrimination in housing. In fact, the common areas of common property may be under the ADA as well as the Fair Housing Act, just on the federal level. But for all of them, remember that the federal law is a floor under which states and locales may not fall. So when you start off at the federal level, that's the basic, most minimum rights. And people that fall within the rubric of being disabled or handicapped. The definition gets bigger as you go to the state level as well as the rights. The same with the city, county, town, village level. As it gets smaller, more rights come about. A reasonable modification, though, generally refers to a change to a structure. Think about steps going up into a unit where someone needs a ramp. A reasonable accommodation generally deals with a change to a policy. Think about a no pet property where someone has an emotional support or service animal. Now, Sometimes it's ambiguous which one you're really talking about, because some are policies and some are structures, but that matters only when you're in the federal or state level. You see, in the federal or state level, we have rules that say a modification the landlord has to permit the tenant to make, so long as it's reasonable, and that's defined by cases, and necessary, meaning causally related to the subject, disability, or handicap. They have to allow the tenant to make it, but the tenant has to pay for it and pay to restore it. Now, when it comes to accommodation on the federal or state level, we find that the law is that the landlord, property manager, maybe condo co-op board, has to pay for it. Now, in New York City, they combine them all under accommodations, and then the landlord, property manager, always has to pay for it.